So with all these division of power rules that we've looked at, how are they applied? If you remember from part one, we looked at section 52, or 52 subsection 1 specifically, of the Constitution Act 1867. It says that the Constitution of Canada is the supreme law of Canada, and that any law that is inconsistent with the Constitution is of no force or effect. So by applying that section, if we have a law that's been created by a government, it could be federal government, it could be provincial government, or even a municipal government. If the validity of that law is challenged, that law can be said to be either intra vires or ultra vires. So those are Latin terms. Intra vires means that the law was created within the scope of the government's authority. In other words, they had a legal right to create that law. Ultra vires means that the law was created outside the scope of the government's authority, meaning the government did not have legal authority or legal right to make that law. So if a law is found to be intra vires, that law is held to be valid. If it's ultra vires, that law would be considered invalid. It's as if the law did not exist. Let's look at a specific case as an example. A long time ago, so this was earlier in the first half of the 20th century, there was butter, and then came along a competing product called margarine. And the people in the dairy industry, especially farmers, dairy farmers, were very concerned that this new product, margarine, would take away sales from butter. So they were able to convince the government, the federal government in this case, to pass legislation. So this legislation was called the Dairy Industry Act. And under a particular section, section 5A, it says that no person shall manufacture, import into Canada, or offer, sell, or have in his possession for sale any margarine or other substitute for butter, basically banning the manufacture, the importation, sale, or possession of margarine, basically making it an illegal substance, more or less. So the validity of that legislation, or this specific section, was challenged or was considered by the Supreme Court of Canada in a case that was, the decision was released in 1949. So the specific legal issue here was whether or not that section 5A was ultra vires of the Parliament of Canada, either in whole or in part, and if so, what particular or particulars and to what extent. In other words, did the federal parliament have the legal rights under the Constitution Act 1867, which back then was called the BNA Act? Did they have the legal right or legal authority to pass Section 5A as a law? So the Supreme Court of Canada rendered its decision here. They said that banning the import of margarine is a valid exercise of federal power under the regulation of trade and commerce. Remember, trade and commerce is interpreted as giving the federal parliament the right to regulate interprovincial and international trade. So they said, okay, you can ban the import of margarine. That's a valid exercise of the federal government's power. But then the Supreme Court also said banning the sale and manufacture of margarine is ultra vires of the federal parliament. In other words, federal parliament does not have a right to ban the sale and manufacture of margarine because that concerns property and civil rights. And property and civil rights is a provincial power under Section 92. So federal parliament, so that part, that banning the sale and manufacture of margarine, was invalid. So they had no right, the federal parliament had no right to do that.